Now let's study some exceptions to the doctrine of privity of contract. Now these exceptions may not be absolute, but there are circumstances. So these are contextual. We need to understand the context, and these are applicable on those contexts. But as a generic idea, we can understand that these are the situations, and on the basis of context, there will be exceptions to the doctrine of privity or the rule of privity. So the exceptions are like trust or charge. Like sometimes under a contract, some benefit is given to a person who is not a party to the contract. This benefit can be given by creating a trust or charge in favor of such a person. In such cases, the beneficiary under the trust or charge may enforce the contract even though they are not a party to that contract. Similarly, there can be some marriage settlements. There are certain sorts of marriages in some communities where there is exception to this doctrine of privity, and there may be some matters pertaining to partition or other family arrangements. So under those circumstances, on the basis of that some context, you can claim exception to the doctrine of privity. Then acknowledgement of payment. If a party acknowledges payment to the third party or constitutes themselves as an agent of that third party, then the third party can recover the amount from such a party. And some other, like there is another exception, like agreement affecting land. If such land is purchased by somebody with the notice of rights and obligations of the owner, then those rights and obligations shall bind the purchaser, although they were not a party to that agreement or contract. Similarly, in the case of agency, a principal, even if concealed, if you are dealing with an agent and you do not know their principal, even if the principal is concealed, may sue on a contract made by an agent. Like the principal can sue the other party or the third party who made the contract with their agent. The third party cannot plead that there was no contract between them and the principal. Now, and in case of assignments, like the assignee of a debt or an actionable claim may sue the original debtor if the assignment is a legal one. Now, holder in due course. A holder in due course of a negotiable instrument is one who has obtained the negotiable instrument in good faith and for valuable consideration. He can sue prior parties to the negotiable instrument. Because we know that negotiable instruments may change hand after hand. So, if a party gets that instrument at a later stage, they can sue the original party. And then there can be a situation where funds in the hands of a party are there. When a fund is created in the hands of one of the contracting parties in favor of a third party, it may be possible to give the latter a remedy in quasi-contract on the grounds that so as to allow the contracting party to keep the fund that would allow unjust enrichment. So, as a general rule, both Indian and English law are similar to each other, that only parties to contract can sue each other. In a leading English case of Tweedle versus Atkinson, it was held that the plaintiff cannot sue, as he was both stranger to the contract as well as stranger to the consideration. This concept of privity of contract was again analyzed in the case of Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited, but that was long time ago, like before 1947 as well. So this was a case, perhaps that took place in Britain, and because we were following British law in India, so we were following the provisions of this judgment as well. Now, position of privity of consideration in India, when there is privity to contract, there is privity to consideration as well. So let's study privity of consideration in India. We will study this in the next video.